On Tuesday, the former chairman of the House Committee on Appropriation, Abdulmunib Jibril, said the House of Representatives could not suspend him because he had sought an injunction from the court, and until the court decides, they had to wait. But then on Wednesday, the House of Representatives went ahead to suspend him for 180 sitting days for breaching the House practice and precedents. In response, the former chairman of the House Committee on Appropriation described the suspension as inconsequential and a waste of time. He also says the action is in contempt of court precedents. I spoke to some lawyers on these issues. Let's listen to them.
I believe, going by the doctrine of separation of powers, the House of Representatives will be in a position to regulate its proceedings, and usually when matters are in court, they do not comment on that. But how far the matter in court has gone, whether the House has been served, is a different thing. I believe Honorable Jibril ran to court to avoid the situation because unbiased observers will see that that will most likely be the next thing.
For those of us who believe in constitutional law, we also believe in separation of powers. Now, interference in each arm is something, if we want our democracy to survive, not to be allowed. Things can be going on simultaneously. Of course, the House has their own powers, they have their own rules, they have their own system. There's no reason why it should be stopped. The House must proceed with what they want to do. The executive must proceed with what they want to do. So also the judiciary. So these arms are meant to continue to function. One checking the other at particular instances or, as a need may arise. But to say that a legislator who is also a part of that arm of government look back into the eyes of his people, because the impression given is that, look, I want to open up everything. Is there any reason why you don't want to open up these things in the House, where it emanated from? Look your colleagues in the eye. Tell them, listen, this is what we did. I was party to it. I'm wrong. We are all wrong. But please, now that we've placed it in the public domain, let's look ourselves in the eye and tell ourselves the home truth. These are the truths I have. Confront them with it. I don't see anything wrong with that.
Parties are to maintain status quo. And what this means is that none of the parties are allowed to take any action regarding the subject matter that is in litigation before the Honorable Court. And having said this, Jibril is in court. The matter is in court. The National Assembly, nor Jibril, none of them are allowed to take any step that will undermine the decision or the step that the Honorable Court will take. So to that extent, the National Assembly cannot take any action till the matter is resolved in court.
To some court stories, the trial of the Senate President Dr. Bukola Saraki and his deputy Ike Ekweremadu has been stalled at the Federal High Court in Abuja. At the resumed hearing, counsel to the federal government Aliyu Umar told the court that he was not prepared to proceed with the trial. He said a motion dated September 26 questioning the court's jurisdiction has just been served on him and he needs time to adequately respond.
The matter was fixed specifically for hearing. We came ready to listen to the witnesses to be called by the prosecution and see what evidence, if any, they have in support of the charges. And we were surprised that the prosecution was rather more concerned with motions for dismissal of the charge, which is a good thing because really the charges we feel should not have been brought at all. So the adjournment to the 7th of October will give us the opportunity to persuade the court that these charges need to be thrown out immediately.
But we had pending applications saying that because it is a matter in which involves the responsibilities of the National Assembly, that they are not within the purview of any offense. That's the reason why.
They have filed applications that are fundamental. When you are saying that another judge is seized with this matter, and you are saying that this court has no jurisdiction, that is more than challenging the charges for duplicity or any other thing. You can never, the Office of the Attorney General can never have this application and then go ahead with the case. I mean, I could have done a better arrangement, I agree. I should have been ready with our response to take these motions. But without that, we have to do the right thing. The government and the Office of the Attorney General must be the driver of the rule of law and fair hearing. And that is what we try to do. If it costs us this embarrassment, so be it.
A federal high court judge in Abuja has withdrawn from the case filed by the federal government against the self-acclaimed leader of the Independent People of Biafra, Mr. Nnamdi Kanu. At the resumed trial, his lead counsel brought an application claiming that the court was biased in its manner it had handled the matter so far. In his ruling, Justice Soho said he had no personal interest in Kanu's trial and would be returning the case filed for reassignment. Kanu, alongside his co-accused, are facing a 6-count charge of treasonable felony brought against them by the federal government. And finally, 4 companies who had admitted to laundering a sum of $15 million are asking the Federal High Court to change the guilty plea. The 4 companies are Pluto Properties and Investments Company Limited, Seagate Property Development and Investments Company Limited, Transocean Property and Investments Company Limited, and Avalon Global Property Development Company Limited.
This is no regular sight in a court environment. The Association of Media Professionals Against Corruption and Instability protested against what they call unlawful witch hunting of the former First Lady Patience Jonathan. Meanwhile, in the courtroom, lawyers are arguing for and against the jurisdiction of the court. 4 companies, Pluto Property and Investment Company Limited, Seagate Property Development and Investment Company Limited, Transocean Property and Investment Company Limited, and Avalon Global Property Development Company Limited are asking the court to change their guilty plea entered into by former Special Advisor on Domestic Affairs to ex-President Jonathan, Warikmamo Owe Dudatha, a lawyer, Amadjoye Briggs, and a banker, Adedamola Bolodeuku. On September the 15th, they had pleaded guilty before Justice Babs K. Wumi to conspiring with 3 others to launder the $15 million. At the hearing on Tuesday, Dudatha and Briggs, through their lawyers, however, state that the court had to change their plea because they were not authorized by the companies to enter a guilty plea. He adds that in the face of the claim by the former First Lady Patience Jonathan that the money belongs to her, allowing the guilty plea by the 4 companies and convicting them of money laundering charges would amount to a gross abuse of the judicial process and an attack on the principle of fairness and justice. But the lawyer to the EFCC, Rotimi Oyedepo, asked the court to throw out the 2 applications, which he described as an abuse of court processes. He argues that it is too late for them to challenge the jurisdiction of the court to entertain the charges after the defendants had already submitted themselves and had been arraigned. After listening to the parties, the judge adjourned till October the 7th for ruling.
Thank you so much for watching, and that'll be all for today on the program. I'm Victoria Ido. For your contributions and comments, please send to @Victoria Ido. See you next week.